I'll be on a Zoom meeting or if you need me. You can just communicate. I do sign language. Do you know sign language? Yes.
Playing the game, huh?
Yeah. How
about you?
They have like a Kenyan 10K run and
We have a running group. I don't run anymore.
yeah, well that's cool. I saw it.
They stole my name and I'm not being paid the rights.
You need an attorney.
Yeah, right.
And I just wanted to make sure we're.
I retired. You just can't get away, can you? I know.
We can stay and let them know when it's time to forward.
And then we'll just do the form.
We'll just do it.
Great. Thank you.
You're welcome. The head of open space and I were working on these two.
Oh, he just got his shots.
Just got a shot.
That's Judge Cole. He'll be the
How are
one.
you?
I'm good. How are you?
Good to see you. Okay.
Good seeing you.
Congratulations.
That's a real insightful answer.
It was great for us to see it.
It's a busy place. I'll tell you. There's just a hell of a lot.
Yeah. No, I mean, it's just.
I should know.
Yeah. That's usually what keeps us hanging on
Oh,
to these positions.
Yeah, that makes sense.
Yeah, but there's that
One last project you want to see complete. I haven't seen a lot of
Always
it.
look it up on our.
Yeah. Well, and then, then you've got.
Absolutely.
Maintenance issues and infrastructure. And
Everybody again.
Find a new Mark Casino. I said, you gotta tell us where when we buy a truck. You know, he's all like, we did that, you know. I said, we buy 10
I know. Every meeting, it seems like we're buying something.
You do need something, again, like to do for yourself.
Shred man.
Oh, it's beautiful. It'll last for a number of years.
I retired in September.
Almost all
I got a phone call here.
Yeah. Well, they were needed. Yeah, that's for sure.
Would you mind stopping in every now and then? Make sure. Sure, I'll help
They
you.
had me.
Yeah, that was a nice.
It's like all the way going down. And Bill Nye was down there, was smoking cigarettes, shotguns, guns.
Every reason to get up every day. Absolutely. My wife is so involved with health and
We got a phone number I don't recognize.
Yeah. Springfield.
Peter's still going there. Now, Oceanside off, they don't.
Yeah.
this is the one where they actually make
We create
high
three
school kids go
more.
in there and they make them take out the
I'll
cancer
tell you.
patients.
Things I've been involved. I've met
But
some.
so yeah, I mean, same thing. You know, she retired about 6 years ago, as a teacher, and but just good.
I want to continue that.
Try to do the things that you love doing.
Staying active and involved in the whole life.
Yeah, I just.
Yeah, I think. it is.
Yeah, I'd like to do that sometime too. I know I should talk to Drew.
Anyway, sorry to.
All right, you're doing a great job. By the way.
But yeah, I'm seasoned, I've done this.
Yeah, yeah.
But I think if I did it for sure.
So yeah.
Ready to begin?
Yeah, you should.
Here we go. I'll get my chocolate.
Lots of things to do.
Real quick, was that your markings or is that somebody else?
That's mine.
That's yours. Okay.
Okay.
Good. Okay. Okay, but I can't get my food open.
All right, everybody, good afternoon. It's slightly after 4, about 4:04, and I'd like to convene the Committee of the Whole, March 30th, 2021. It's Tuesday. So could we please have a roll call?
Allen,
Allen present.
Bates,
Bates present.
Berman,
Berman here.
Brown,
Here.
Davist, Ford,
Here.
Ross,
Raz here.
Iqbal, Combs,
Here.
Kenyon,
Here.
Caius,
Vice President.
Kopi,
Colby's here.
Leonard, Lewis,
Lewis, yes.
Martin, Molina,
Molina present.
Sanchez, Shepro,
Jeffro present.
Silva, Strathman,
Present.
Sturgis,
Present.
Tepe,
Present.
Weber,
Present.
Warnicki.
Present.
Okay. Thank you all for being here and giving up your time to listen to, I think, what's going to be 2 very critical conversations that we're going to be having about things that are happening here in Kane County that I wish we didn't have to address. And then the other one was going to be talking about the Open Meetings Act. So that's going to be our agenda. So before we begin, are there any public comments?
How about the Pledge of Allegiance, Corinne?
Yes. Do we have anybody online?
I think they said, what about the Pledge of Allegiance?
Oh, excuse me. I forgot our Pledge of Allegiance.
In minutes.
Could Jim, you're going to be leading us? My apologies.
That's okay.
Test. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands,
One nation, under God, indivisible, with liberty and justice for all.
Thank you, Jim. I appreciate it. And the liberty and justice for all is, I think, is going to be the impactful part of today's earlier part of our conversation. So again, are there any public comments?
How about the minutes, Corinne?
Oh, my goodness sakes. You can see I want to get to this conversation. Thank you. I will go very carefully through the rest of this. We got the Pledge of Allegiance. Now we're going to have the approval of the minutes.
Dice move.
And
Jeffro, second.
Thank you. Are there any thoughts, comments, or changes to the last executive board minutes?
Those would be the committee of the whole minutes.
That's correct. Hearing none. Roll call, please.
Allen,
Allen, aye. Bates, aye.
Berman,
Berman, yes.
Brown,
Yes.
Davis, Ford,
Yes.
Bras,
Yes.
Iqbal, Gums,
Yes.
Kenyon,
Yes.
Caius,
Dice, yes.
Kobe,
Colby, yes.
Leonard, Lewis,
Lewis, yes.
Martin, Molina,
Molina, yes.
Sanchez, Shepro,
Jeffro, yes.
Silva, Strathman,
Yes.
Sturgis,
Yes.
Tepe,
Yes.
Weber,
Weber, yes.
Winnicki,
Yes.
passes.
So now we're on item number 5, and I'll ask again.
Public comment.
I have my check marks. Any public comment? And is there any public comment online? No?
Nope.
So there is no public comment. So now we can go on to item number 6, presentation and discussions. So at this point, I'd like to present Representative Gloria Kelly, who's the Executive Director of Casa. And she's going to share with us what Casa has been up to during this last year and share her need and her concerns for the children here of Kane County. So thank you, Gloria.
Thank you. And I just want to say thank you and for inviting me out today to present Madam Chairman and also the Board of Directors of Kane County. Fortunately, I know just about everybody in this room and many of you I've worked with from time to time. I've had the wonderful and unique experience in being the Executive Director of Casa Kane County for 14 years. And we are just going into our 33 years of child advocacy, second to Cook County. And alarmingly to know, but we've served more children in Kane County than we did in Cook County. So I will get into a little bit of that. 564 children were served in 2020, comparison to 458 in abuse and neglect in 2019. Our caseload right now per supervisor, and I have 6, is at an alarming 45 to 50. And we are seeking out and seeking more funding through some grant opportunities for another advocate supervisor to keep up with the growing demands and needs. So the COVID effect. In late November 2020, our courtroom closed to the public access, and all proceedings occurred remotely, creating some unique challenges. We still cover court cases 5 days a week from 9 a.m. until the court concludes the hearings for the day. We hope to complete as many proceedings as possible to curtail the pandemic's impact on children's permanency goals. Through incredible work effort in our recruitment and our stewardship, the CASA staff has reduced our caseload to approximately 60 children without an assigned volunteer, which is our first in the organization's history since the beginning. So supervisors and attorneys have conducted the monthly visits. We've gone over and beyond, dropped off presents, given incidentals that are in need from basic formula and diapers to clothing. Every child in our program also receives a backpack or a baby bag with incidentals. And we've also attended all case meetings and staffings in and out of court, along with their other responsibilities. So our increased demand and the additional cases overwhelmed by caseworkers who are already stretched very thin, creating delays in response to services and communication. So basically, just in this week, we conducted multiple hearings and where we saw gaps in services. With our advocate supervisors and our incredible Casa Jail volunteers, we have overcome these obstacles and provided the court with the necessary information to help avoid delays in the proceedings. We are very humbled and amazed how incredibly gracious our volunteers are with sharing of their time. With having a full-time staff of 20, we also have 200 Casa GAL volunteers that really act as, in a lot of ways, part-time employees. We have to screen and work through educational compliance issues like we do with our employees. And that has to be recruited, the training, and again, everything that goes along with running a business. So over the past few months, our cases have continued to provide complex and compelling issues. In one case, we found ourselves giving comfort to a child and family members whose mother was found in a motel from a suspected overdose and appointed to a child whose mother was murdered by his father in a domestic altercation. However, we have also witnessed many success stories, including adoptions completed after years of advocacy and return home to parents after they have completed services. To achieve those great successes, we have happily taken on extra cases, dealt with the time frames in the courtroom, and continued to overcome the instability and consistency of some of our agency partners. So we have held steadfast to our mission, and we are proud of the CASA staff and our leadership and our CASA volunteers' resilience of the consistency and strong advocacy that we provide for children that we serve and working with our judicial partners. And we are grateful for that. So as many of you know, being around this organization, I'm just looking at time, being respectful, being here for 33 years, we've gone through some significant changes. And I am always grateful for the people who founded this program many years ago because they had vision. They had vision to bring this program to a GAL status in 1992, whereas most of my sister CASA programs, there's only 8 who have that status in Illinois. So we are broader than the program here. Some people think it's just Kane, but we're a pretty powerful movement with over 1,000 CASA programs nationwide, but 38 within the state of Illinois. And fortunately, within the last 3 years, we've gotten a stronger state program who've helped many of our other sister programs. And in that, since that 92, going into probate, which we've unfortunately had to put on hold. So probate began with CASA, and there's only 2% of the CASA programs within the nation that actually do probate court. And it is such an important part of what we do is that we actually appointed and hired a full-time attorney to represent us in the probate court. And as many of you know, being on the board for many years, 3 years ago, we had lost the public defender who represented CASA in court. So, that was a long time coming, and it was a good service, and it helped us financially. But anybody knows, within a team or organization, you want people that actually, that you're working with day to day. So fortunately, I was able to hire 2 amazing, incredible people that used to work for the state's attorney's office who represent us both in abuse, neglect, and in probate. Again, probate's being on hold right now until we can meet all of the needs. And right now we are recruiting a group of CASA volunteers of 60, which is, again, is one of our highest. We're promoting, I've given packets to everybody, and there's a flyer in there. And I always say, if there's anything that I ask of anybody that I have a moment to speak in front of, is to please get that out for us, help us find some CASA volunteers to help us work with children who need our help the most. And we're also looking, fortunately, for another advocate supervisor. Training starts in May. And again, we're hopeful with that new class, we'll have assigned every new CASA volunteer to every case that we're appointed to today to be even caught up. So, and with that, I can open up any questions and just thank you for the opportunity to speak with you today.
Does anybody have any questions for Ms. Kelly? Yes, Mr. Surgis.
I am uniquely biased in this. Congratulations, Gloria. My wife is a CASA that works under Gloria. Because we live at the extreme north end of the county up in Gilbert's, Audrey has had the pleasure of serving both the McHenry County CASA program as well as the Kane County CASA program. And I can report without a hesitation in my voice that this is the finest group of people that I've ever seen. And your time is the most thankless and important in the life of a child. And I thank you for everything you do. So
Thank you. That means a lot. And I'm going to share that with our team. Thank you.
Anybody else?
Madam Chairman, this is Alan. May I ask a question?
Absolutely.
Sure. Ms. Kelly, could you explain just a little bit about who your partners are? You have referred several times to partners. Are they judicial or extrajudicial or social agencies? Or can you just give a word or two about them?
No, I appreciate that. So we are here in our greater umbrella of judiciary partnerships. We look at our judiciary. So our judiciary and of course the national and state organizations of Casa is important, but we're here to help and serve with our judiciary to help our judges make the best interest decisions for children in care. So remember that everything to do with our recruitment, our funding, and I also want to state and want to thank you guys for over 20 years of your support to our program. You've provided our space, and thank you for that. We have a lease agreement and we have a use agreement for the space for the garden. And because of your support, we've received $1.2 million through over the 20 years for Casa. So our partners, first and foremost, are with our judiciary, and our partners are with you, the Kane County Board. Our partners are with our donors, our leadership, and our partners are with the agencies, because we work collectively but very independently of them. And so again, our role, which is very different from a lot of the other agency partners, is that our mission is to state we are here for the best interest of the children, and our goal within the 16 judiciary is always a return home. If parents can be better parents, and when that doesn't happen, we're going to work very hard for other permanency goals of adoption or other guardianship.
Okay, very good.
Thank you.
You're welcome.
Any other questions? So I have one. You mentioned it was 564 children you are seeing right now?
Yep.
And that has been a growth of approximately 100 over this last past year. Do you have an increase in projected growth, or do you feel that it's going to stabilize?
That would be, I wish I had that exact question answered, and it's always a good one, Corinne, because when I started here, I remember going to our chief judge and the state's attorney's office and asking them, help me understand, project it. And unfortunately we can't, but I can tell you that with the rise of COVID, and I think because of what has happened with the AJ Freed case, they are not letting one thing pass by them. So, I always say AJ's death was not in vain. He helped, unfortunately, bring together the more ears and eyes. And April is a very big month for everybody across the nation, is to see something, say something. And I'm very proud to share with you, with the Sheriff's Department, the ROE, and the State's Attorney's Office, we have a mandated reporting packet that's going to be mailed to every mandated reporter of 3,000 people that's coming soon within the county. And we're going to be doing a press conference within the next 2 weeks with Jamie D and Pat DeSantro from ROE, and also with Sheriff Hayne.
Very good, very good. And could you just, for all of us, could you just please, and for the people who may be listening, what is a mandated reporter?
A mandated reporter is someone who should, regardless if you work within a school or with children, you have to legally call if you see or suspect any abuse of a child. And what we're trying to do is raise the level of awareness, and we are doing this through a podcast, being mandated reporting. I'm actually going out and speaking a lot in the month of April to people saying anybody can be a mandated reporter. You know what, don't let the title get in the way of doing what is right. So if you are a teacher, you are mandated by law. There's a list of it on our website under the mandated reporting toolkit. But if not, and it's in your folder, but we're just trying to encourage all people, if you see something, say something, make the hotline call, and you have nothing to lose, and they have everything to lose if you don't.
And that number to call is?
1-800-25-ABUSE.
Okay. All righty. All right, any other questions? Well, thank you very much, and thank you for your service and continued service to the children here of Kane County. I know that you have saved many lives and will continue to impact many, many children, unfortunately, yet to come. And I look forward to the time that your not-for-profit goes out of business.
So do I. So do I. Thank you.
Thank you.
ma'am. Thank you all.
The next part of our agenda will be a presentation by Chief Judge Hall.
Good afternoon, everybody. We're going to start out, Mr. Naughton's going to pass around the PowerPoint that we're going to show up. And while he does that, I want to introduce our team. We have Judge Parga, who is our juvenile delinquency judge. We have Lisa Ost, who you know, who's our Director of Court Services. We also have Chris Allen, who you know, who's here, and we've been working very closely with on the project, and then Doug, our court administrator. So starting with the first slide, what I wanted to indicate is that it's very fortuitous that Ms. Kelly was here because we work very, very closely with Casa. Just as she indicated that they serve the children who are in our abuse neglect courtroom, that's exactly why we're here today, because we're in a situation where the numbers are so high and the numbers are so great in Kane County that we feel that we need to try to build a second courtroom in order to deal with that increased population. And so our goal is to get approval and to have a second courtroom built out at the Juvenile Justice Center by January 1st. Next slide, please. Madam Chair, when you were asking Ms. Kelly to project what the numbers look like for this year, I'm afraid that we're going to be higher than we are this year. And when you look at that in the slide, what we do is we look at each year how many abuse neglect cases came into our system. 2017, 59, 2018, 70, 2019, 110, and then last year you can see a 204. So an almost 80% increase. The question is why? Couple things. One is she referred to the A.J. Fruitt case, but it was a case in McHenry County where a young boy was killed by his mother and father. And as a result, DCFS did a complete 180 on how they dealt with cases. Before that case, if they ended up getting called and wanted to help with the family, they would try to keep the family intact. In other words, they did not come to court. They tried to work with the family to provide services and then to try to keep that family intact without ever having to come to court. After that case, there were a couple DCFS workers that were charged with neglect. That case is still pending. But DCFS changed the way that they approach these, and now everything's coming to court. So just when you look at 2021, when we put the PowerPoint together, as of March 15th, 53 cases. So if you look at it from a quarterly approach, we weren't even done with the first quarter, and we were about at the same level that we are now. So when you look at what we're projecting for 2021, the need's going to be greater this year than it has been in the past. So then the question becomes, what do we need to do with that? And I'm going to turn it over to Judge Parga. I asked her to come because Judge Parga is our delinquency court. And just so you have a frame of reference, we have a delinquency court. We have one courtroom over at the JJC, and that's where Judge Parga sits. The delinquency court is currently at the 3rd Street Courthouse. And I'm just going to explain and let Judge Parga go through how that impacts how they deliver services and why it would be so beneficial to have those courtrooms together. Judge Parga?
Good afternoon. Thank you for giving us a few minutes to speak with you today. So as Judge Hull was saying, our numbers are going up, and abuse and neglect cases right now are heard in Geneva in courtroom 140. It's an older building, as everybody here knows. The room itself is rather small, and abuse and neglect cases involve a lot of parties. On average, there's going to be anywhere between 6 to 10 people who have to be in the courtroom with the judge, and it's small. But aside from the space of it, we really believe there's 3 important goals that could be met if we combine the abuse and neglect call with the delinquency call, which is at the Juvenile Justice Center in St. Charles, where I'm located. That building in St. Charles is exclusively for children. The only people who come through the doors are the families with their kids who are having cases heard there. So unlike in Geneva, where there are other civil matters being heard, and there's other parties around and coming in and out, here the children are protected from all of that. There aren't any other adults coming in who are not specifically involved with those cases. So what we see the goals to be are, 1, being able to better serve the needs of the kids and families who are duly involved children. And a duly involved child is a child who has had contact with the Child Welfare Service, Department of Children and Family Services, and then gone on to have a case in juvenile delinquency court. And statistics have shown that children who are involved with DCFS, who have had contact in the child welfare system, are at higher risk of then having involvement in the juvenile delinquency system. So if we're able to combine our courtrooms into the one building, we believe that we're going to be able to better serve and make sure that those families are receiving the services that they need to promote their family's well-being. And we accomplish this because the judges being in the same building would be able to hear a mix of both abuse and neglect and delinquency cases. Right now, we're divided. So if a family is duly involved, they will go to Geneva for the abuse and neglect portion of their case and then come over to the Juvenile Justice Center for the delinquency portion. So having us together in one building, the families can eliminate that. The judge can take a more holistic approach to the file and will be more familiar with both aspects so that, again, the services that we are providing are addressing the needs that brought the family into court, into both parts of that court. And lastly, the Juvenile Court Act requires us to protect the privacy and confidentiality of children. That's really difficult to do right now in Geneva. If families need to speak with their caseworkers or their lawyers, there's not a lot of room within the courtroom. And then in the hallway, there's a lot of other people passing by who have to pass by. They're there for their own cases and conducting their own business. So it is very hard to protect the confidentiality and privacy of the kids. At the Juvenile Justice Center, again, we're completely dedicated to maintaining that privacy, that confidentiality. It's completely child-centered, focused, and the public isn't coming to conduct any other business because they are only there to address those cases. So those are really the three big benefits we see from combining the two courtrooms and addressing this growing need with the abuse and neglect cases. And just touching briefly on the number of the cases, on average, we're seeing about 3 cases come in weekly. And those cases are what are called shelter care hearings. It's when the department takes protective custody of a child and it triggers the start of the case. There was one week not too long ago where I heard 5 of those shelter care hearings in 1 week. So the numbers are going up. There is a big need to make sure that we're addressing the reasons why the families are coming in, that the services are appropriate, and that we are taking a holistic approach to addressing those needs. So thank you.
Next slide, please. So again, being cognizant of the county board and how many people come in front of you asking for money, there's a couple things that we had to do. First is we talked to Cordigan and Clark, and it was fortuitous. There's a poster back here that was put together when the original JJC was built. And they found it in a closet, and it goes through, and what it talks about all the way at the bottom is the fact that projected expansion, and then the expansion was that they were going to have a second courtroom at the JJC. It's just never been built. So we had to go through and we did some architect plans, and Cordigan and Clark priced it out at $851,548. Couple things that are important and that we've worked with Mr. Allen on is, we're good. But a couple things that you should know is, number one, there's no additional, this isn't an addition. We're not asking to build on to the JJC. What we're asking to do is the original design called for 2 courtrooms. So this would be the build out of the second courtroom. Currently, the public defender's office is in that space that we would use. But so again, we're using the available space. Next slide. Again, for those of you that we handed the PowerPoint out to, it just gives you an idea of where we're at and what the courtroom will look like. There are space considerations. The state's attorney's office and the PD have offices over there. The design was able to keep those offices. We've reduced those. But again, this will allow us to have 2 courtrooms over at that facility. Next slide. The biggest thing that we always consider, because we have to think of it through your eyes, is how are you going to pay for this? We believe that we've come up with some different ideas that will allow the county board to do that without with the current budgets that we have in place. Number one is, as you know, although it's been a very tough year, there have been some savings that have resulted because of COVID. And we in the judiciary and court services have been the recipient of saving a considerable amount of money, not only last year, but we also are projecting savings this year. Our goal is to use those savings to be able to apply it to build this courtroom out. So this is what I would say a one-time opportunity. The line items that they would come from or the different departments would be judicial and courts and court services. Next line item. Mr. Naughton is here and can provide specific details if you'd like those. But when we look at judiciary and courts, the money that we are going to be saving or the line items we're going to be saving in is jurors and juror expenses, consulting, bond call, and court-appointed counsel. And just briefly, with jury trials, we have to pay, the county pays for jurors to come in, service every day, mileage every day. But because of COVID, we were unable to hold jury trials for most of the year. Right now, because of COVID, we can only hold 2 jury trials each week. And as a result, we're going to experience significant savings in that line item. Contractual and consulting services, the county budgets about $450,000 for interpreters every year. Because court has been closed for a considerable amount of time, we've had savings there. Judge Parga and Judge Cruz also were instrumental in connecting us with an interpreter service that does this remotely, so it saves us on mileage. And in addition, because they're certified and registered, the AOIC has paid for them instead of us paying for them. So we're going to see considerable savings in those line items as well. Next slide. On the court services side, when we look at juvenile board and care, there's a $400,000 budget item, and that's used for placing juveniles in different placement facilities. That is something we use almost every year, but not this year because this year, because of COVID, placements weren't accepting kids. So that's going to be a savings we expect this year of somewhere in the neighborhood of $400,000. And then Director Ost has also gone through to see where else we could save in other line items. The third, next slide. What is another line item that we discovered since we presented in front of Judicial and Public Safety is the Judicial's facility fee. Now, this was a fee that was initially put out and passed in 2015 by the legislature, but Kane County decided not to collect that fee until recently. We did look into that line item and found that there's a balance of approximately $979,000. And the purpose of that statute is to help build new judicial facilities. And I would indicate, and we did talk to the state's attorney's office to ask for their opinion, if we could use this for the second courtroom, and they indicated that in their legal opinion, we could. So those are 3 potential funding sources that would take care of the $856,000 project. Next slide. Our request of you is, right now, I understand that for the committee of the whole, this is educational only. But what we're looking for the county board to do is to authorize the use of capital funds to build out the second courtroom. This isn't anything that's been budgeted for us right now, so we don't have a line item to go to. But what we would like to do is ask you to fund that and then for us to give you the savings that I just outlined. We did come in front of Judicial and Public Safety the last budget year because we had hoped to be able to pay for this facility using probation fees. The AOIC said that we were unable to use probation fees to do that. But at that time, we had come to Judicial and Public Safety to ask if the county board would consider contributing to this project. And at that time, Judicial and Public Safety had indicated that they were willing to roll over $125,000 of last year's savings. Now, we never got that to the full county board because the AOIC quashed our funding proposal. Next slide. The timeline that we're projecting was to go in front of admin on April 14th. Our hope is that we would have this approved and then to go in front of finance April 28th, exec committee on May 5th, and then have a full county board vote on May 11th. So that's in a thumbnail what we're looking to do. We would be happy to answer questions. Again, we have Mr. Allen here for any building and grounds. We have Mr. Naughton and Lisa Ost here. And then we also have Judge Parga and myself. So are there any questions at all about the project?
Fries has a question.
Excuse me, Mr. Foz, Mr. Tepe first.
Yes, earlier you said that the offices there were being occupied by the public defender and by the state's attorney.
Yep.
Where would those people go and what are the costs associated with that?
Well, what we did is we made those offices a lot smaller. So it's the same space. The public defender's office is a gigantic space with just one person. But the architects were great about trying to figure that out. And the state attorney's office, and Ms. Masser knows this, we had to cut significantly into theirs, but there are spaces for them to use.
I thought you were just going to pawn it off on them.
Yeah, no, it's gonna be tight. I don't think we're gonna have any fans when we do that, but we did have to look at it and really try to figure out where to put them.
But it's not a significant cost.
No.
Mr. Frost?
I had two questions. Are the plans that you have from Corrigan Clark, are they complete or are they just conceptual and will need to be completed?
No, they are complete. Now, the RFP hasn't been done, but they came over, they've drawn them out, we've paid for those, and so they're ready to go to bid upon approval.
Okay, then my second question, going back to one of your first slides, I guess I'm kind of astounded on the caseload. And I just was wondering theories on why this caseload has, tripled on its way to quadrupling just since 2017.
Well, so I brought this up to there's the Administrative Office of Illinois Courts that oversees all the court systems in Illinois. So I brought this in front of them. We have a conference of chief judges where I wanted to know if this was unique to Kane County. And so they decided that they wanted to take a look at that. And what they found is it's not unique to Kane County at all. In fact, since 2014, all the counties have experienced a significant uptick. And we've asked the DCFS director to come speak to us at our next meeting to try to explain why that is, what's changed, and most importantly, how we should plan for that in the future. Because all the counties are in the same position as we are right now in experiencing, not every county, but most counties, especially in our area, have experienced that same uptick.
Okay, thank you.
I think Judge Parga could tell you that your day, your and Judge Karianis's day starts at 8:30 and doesn't end until after 4:30 most days.
Yes, that's correct. So we are doing as much as we can remote and scheduling throughout the day, but we do start at 8:30 and really go all the way to 4:30 hearing different cases. And the abuse and neglect cases are very involved because you are trying to hear recommendations from Casa, you're trying to hear what services have been done, you're hearing from the Department of Children and Family Services, their caseworker. So everyone has a bit, and it's our job to take all of that information and see what's working and what's not. So the cases are lengthy. They aren't a quick status. I would say on average, a case will take anywhere 25 to 30 minutes to hear it. But yes, we're busy.
Dates, please.
Mr. Hall.
No, that's okay. Did Ms. Allen have a question?
Bates.
I'm
Yes.
sorry.
Mrs. Bates.
Madam Chairman, does this impact the parking over there? That didn't look like a very big parking lot to me.
It would not impact the parking. We would be bringing more cars over there, and I guess Ms. Ost, I've never seen that parking lot. There's an employee parking lot. We don't think that it would cause any problem or require any additional parking at all.
Okay, thank you.
Yes, Ms. Wodnicki.
Thank you, Madam Chair. I just want to thank the Chief Judge and the Judiciary for, you have the foresight to put that money aside, knowing that this is something that was going to be needed. And that's pretty rare, especially when we're budgeting, and budgeting is getting to be very tight, tighter and tighter every year. So thank you for that. Appreciate that.
Mm-hmm. Absolutely. Yes, Mr. Surges.
Madam Chair, you know what, oftentimes you hear the phrase that, something just slipped through the cracks. Well, these are the people that keep those children from slipping through the cracks. And all they're asking us for is a little bit of help. That's it. Money's budgeted, it's there. They're just looking for some help. And Judge Hall and your entire team, you have my support, and I encourage my fellow commissioners here. So
thank you.
Any other questions or comments? I do have one.
Sure.
And it was addressed, started being addressed by Mr. Froz. Obviously, these are children who are in a tragic, very fragile situation, and one that we would never wish upon anybody, not even one of our pets. So our heart bleeds and breaks for each one of them. But to go past that, what are, again, the root causes that perhaps we can start taking a look at here in the county? Is it employment? Is it education? Is it insecurities for whatever reason? Is it mental health issues, addictions? And as those are being found out from your resources, if they can be documented somehow so that we know, working with our adults, with our parents, with people in the community, how we can best start taking a look and how we may take a look at those and possibly address those concerns and those needs and do it direct and point. So it's very specific help. As I know we can do a broad brush stroke, but I believe that if we take a look at the actual root cause of this and try to do a couple of projects that are substantive and meaningful to address the parents, because it has to come through the parents as well, and to be of help.
No, and it's in all of the above. I mean, you hit on all of them: alcohol, drug abuse, mental health issues, poverty, food insecurities. I mean, every case has at least one of those. Most of them have multiple. But just going back again to what Judge Parga said, the benefit of combining these two courtrooms and putting them in the same place allows us to address those situations so much better and address the families together instead of sending them to two different locations. And so we do, the DCFS and AOIC keep those statistics. We'd be happy to sit down and talk to you about that. To address your holistic idea, through Judicial and Public Safety, we did contract with a facilitator, Mr. David Olson. He's a professor at Loyola. We're meeting next week for him to sit down and meet with the entire judicial team. When I say entire judicial, state's attorney, public defender, court services, to sit down and help guide us for you to try to prioritize what our needs are, to see if we can reach consensus on what those needs are, so that we can come in front of you with and Chairman Molina from Judicial and Public Safety was instrumental in that as well, trying to put it all together and address these so that we can make a dent in this. And again, with Casa and the partnerships, you said, we'd love to see it go out of business. Mm-hmm. We'd love to see Judge Parga doing something else and Judge Kirianis doing something else.
Absolutely.
But we have two, the last thing I'd say is we have two fantastic judges, and Judge Kirianis and Judge Parga. They'd never ever say it out loud because they're so humble, but it takes a special type of judge to be able to do this court call for all the reasons that you've said. And they both stepped up and they do it day in and day out. They look for ways to take the initiative to make it a better courtroom and to help the families. And so I couldn't be any more proud as a chief judge of the two people that we have in there.
I think we all would agree with that. Yep. So if there's no other questions, thank you very much for a very thoughtful presentation.
Thank you for your time.
So the next agenda item is going to be about FOIA presentation, and Assistant State's Attorney Aaron Brady will be doing the presentation.
Excuse me. Good afternoon. I'm going to actually be talking about the Freedom of Information Act and the Open Meetings Act today. In light of the transition and new makeup of the county board, we've been asked to provide either a primer or a refresher, whatever as the case may be. I know many of you know all about this and are experts already, so please bear with me, and I will do my best to move as swiftly as I can while devoting appropriate attention given the nature of the matter. Next slide, please. So the Illinois Freedom of Information Act and Open Meetings Act promote transparency and accountability in government offices. The employees and officers of public bodies are required to know a number of important rules and procedures in order to carry out their duties. These were part of an overhaul in government transparency laws known as sunshine laws. Beginning, I believe it was 2010 was the first major overhaul for Foia. And everybody's pretty much familiar, I think, with the outline of the obligations under Foia, but let's start there. If you wouldn't mind going to the next slide, please. So the overarching theme of FOIA is that public documents are accessible for inspection or copying, and that public bodies within 5 days of receiving a request for a record must provide a written response to the requester with the documents or with a appropriate denial letter. Next slide, please. Everybody is entitled to a full and complete set of information about the affairs of government and official acts of policies and those who represent them as public officials. That's a very broad policy statement bending toward the access of documents by the public of public records. Next slide, please. And what is a public record? Basically, it's anything pertaining to public business that's construed very, very broadly. And it's presumed that all records, all documents in the possession of a public body are open unless they are proved exempt by a clear and convincing standard of evidence by the public body denying their inspection. This includes any kind or category of record, written documents, electronic documents, emails, text messages, and it's not limited necessarily to a search for county systems or county devices. If it's anywhere and it's discussing public business, it falls within the parameters of a public record and should be reviewed for disclosure if it's requested. Next slide, please, Blair. Public records include specifically records relating to the use of public funds, payroll records, arrest records, criminal history reports, settlement agreements by a public body. The exemptions that permit a public body to withhold the release of certain documents, if you wouldn't mind, Blair, please, the next slide. This is not an exhaustive list, but these are some of the more frequently seen exemptions asserted just by, in our experience, working with the county and some of their FOIA officers. Information that's prohibited from disclosure by other laws, private information, personal information like Social Security, personally identifiable information like phone numbers, something that would be a clearly unwarranted invasion of personal privacy is exempt. Active law enforcement or administrative law enforcement proceedings are exempt. The reasons behind that would be if disclosure would interfere with a pending law enforcement investigation. For example, if a police office or department was conducting a criminal investigation and there was information that was not yet public, the idea being disclosure of certain investigatory information could interfere with whatever route they eventually end up going down in that investigation, and the police department could exempt it under that basis. Additionally, draft documents where opinions are expressed or policies are formulated can be exempt. However, an important note there, when a public body or officer mentions a public document, or I'm sorry, a draft document like that in public, the exemption is waived. Getting into procedure, public bodies can request that a FOIA request be in writing. However, they can't require that it be on a specific format. If someone wanted to submit a FOIA request on the back of a business card or napkin, they could do that, and the public body would have to honor it. They may also choose to honor an oral request if they so choose. Whenever a public body receives a FOIA request, any member of the public body, it's important to immediately forward it to the designated FOIA officer for the public body. Timelines are very stringent here in FOIA, and it's very important that the appropriate clocks start running and all of these steps be taken as soon as possible. So if your FOIA officer is out of town on vacation or something like that, the public body doesn't have any sort of leeway. They still have to have someone else designated to fill in their space while they're gone. Elected officials and county departments typically have their own FOIA officers, and sometimes they'll communicate with us if they need assistance, but by and large, every county office has their own. For the county board, for example, I believe it's Karen Miner currently, and so she's the county board's FOIA officer. A FOIA officer is supposed to make a notation of the date a request is received, figure out the date for a response, create copies and files of the requests that come in, and maintain separate files for FOIA denials. FOIA officers are required to complete a separate online training by the Illinois Attorney General's office before they are so designated. They must also post certain FOIA information about how to communicate a FOIA request on the government body's website. And requesters are allowed to either inspect or copy documents at their preference. There is a fee schedule. I'll talk about that in a moment for certain voluminous document requests, but as I say, it's up to the requester. If they want to inspect them rather than copy them, they can do that. As I mentioned, next slide, please. There's a 5 business day clock for a written response to a FOIA request. The public body can ask for an extension of 5 additional days for certain exceptional reasons, such as documents being stored off-site, or they're the type of documents that professional review needs to be done in order to determine certain exemptions. Requesters can agree to longer extensions beyond the 5 days, but typically it's a 5 business day deadline. If a FOIA request is for a commercial purpose, the public body's got 21 days to respond, so they've got a little extra time there. Next slide. As I mentioned, there is a fee schedule. The first 50 pages of a FOIA response are free. After that, 15 cents a page. If someone is requesting documents in an electronic format, those can either be emailed, or if they're too big and a jump drive is needed, or some other hard drive or device, the public body can charge the requester for that device or that storage system. And this only applies to fees where they're not already fixed by statute. Some county offices have statutory fees for some of their documents, like the circuit clerk has copying fees, or the coroner's office has coroner's report fees that are meant to offset the cost in preparing and creating those documents. And those where statute explicitly says, a different charge can be made for those documents, that trumps the FOIA provision for fees. If the consequences for failing to respond within the 5 days or other agreed upon time, if you don't respond, it's considered a denial. It's considered that you just denied the request entirely. If the public body doesn't respond within the time permitted, they may not charge that fee, that 15 cent per page beyond 50. Also, if there's no response by the public body is barred from treating the request as unduly burdensome. The unduly burdensome exemption is a very specific process that works toward the public body and the requester working together to try to frame manageable parameters. It's not an exemption that I've seen upheld very much in Attorney General opinions. It's generally, there's a long process to be used before that's asserted. Next slide, please. After that 5-day time period, the public body has to send a letter granting or denying the FOIA request. It's got to be in writing. It's got to state the reasons for any denial, including a specific citation to which exemptions you're using. It's got to notify the requester of their rights for judicial review and review by the Public Access Counselor, or the PAC, which is a branch of the Attorney General's office devoted specifically to hearing complaints and allegations about FOIA or Open Meetings Act violations. As I mentioned, the unduly burdensome process it requires that there first be an opportunity for the requester to confer and narrow their request before that exemption is asserted. And a public body can grant and deny in part, meaning they can provide certain portions of the records or certain records and then deny others based on particular exemptions. For example, very often you'll see documents being provided where personal information is exempt, so you have several pages with someone's home phone number or address blocked out, redacted out, and that would be a technical deny in part. Next slide, please. So upon receiving a denial, a FOIA requester can ask for a review by the PAC, and the PAC it must be filed within 60 days. The PAC does an intake process and reviews to determine whether further action on their part is warranted. They send a letter to the public body and to the requester, and everybody gets a chance to explain their position in writing. The PAC can issue a binding or a non-binding opinion. The binding opinion is one that has consequences for a judicial review. A non-binding one is advisory in nature. What happens is if someone gets a binding decision and tries to enforce that in court, there are consequences and presumptions that are made against the public body if they continue to refuse to provide the records that the Attorney General PAC said that they should provide. Separate from the PAC review process, if someone's denied, a requester can file, or I'm sorry, next slide please, sorry, can file a lawsuit within the circuit court for an injunction. Next slide please. Thank you. Attorney's fees are permissible for a successful plaintiff in a case like that. And if the court finds that the public body willfully, intentionally violated the act and withheld documents, there can be fines ranging from $2,500 to $5,000. Next slide, please. During the pandemic, the Attorney General's office really has not changed the statute. However, they have issued guidance suggesting that requesters should try to be understanding and work with public bodies to allow reasonable exemptions. All other obligations remain the same. The AG acknowledges that public bodies are overwhelmed with the response to COVID and that sometimes FOIA responses can be delayed as a result. Moving on to the Open Meetings Act, similarly as with FOIA, the intent is to encourage open and transparent government. It's the intent of the Open Meetings Act to ensure that the actions of public bodies are taken openly and their deliberations conducted openly. Citizens are also supposed to be given advance notice of a meeting and the business that's going to be considered or acted on at the meeting. A meeting is defined as the gathering of a majority of a quorum for public business or purposes. So, for example, many county standing committees have 7 members. A quorum of that 7 to open a meeting would be 4. A majority of that quorum would be 3. So 3 members of that public body discussing public business would have to notice and provide an agenda for a discussion prior to it being had outside of a public setting. Next slide, please. As a reminder, every member of a public body upon taking office is supposed to complete an electronic training program developed by the Public Access Counselor. If you need any assistance with that, please reach out to us. But beyond that, once you get your certificate, you should file that with the county board office and they'll hang on to that for you. Once you take it once, you do not have to take it again. But if you're new to office, new to the county board, that's something that needs to be done. Next slide, please. All meetings are supposed to be open except where they're allowed to be closed. A county or a public body can close a meeting subject to certain conditions. These are examples only, not an exhaustive list. However, when a motion is made to go into a closed session, the public body has to state the basis for the closed session. So for example, here we've got discussion, employment, compensation, discipline, or dismissal of specific employees, collective bargaining matters, discipline of public officials, real estate matters, litigation matters. Those are some of the more frequently seen exemptions. As a reminder, no final action may be taken in a closed meeting, so no votes can be made, no decisions can be made that bind the county or the public body going forward. All meetings are required to be held at specified times and places that are convenient and open to the public, and they may not be held on legal holidays. As to public notice and agenda, we've got to give 48 hours of all public meetings that are posted on the website and are posted at the physical location of the public body. At the beginning of every year, public bodies are supposed to publish a list of all of the meetings they will have for that year. And that's something that we do, on an annual basis. As I mentioned, the agenda's got to be posted on the website containing a summary of what's going to be the subject of a final action. something that's not on the agenda may be discussed, at the appropriate time and with appropriate recognition during, either new business or old business, depending on what the case may be. But no vote can be taken unless it's been noticed and on the agenda. Notice an agenda of a special meeting under the Open Meetings Act is 48 hours as well. We have some additional requirements under our own county code, but the Open Meetings Act itself gives 48 hours. Some additional important points under the Open Meetings Act: public bodies must keep written minutes of all of their meetings. The open minutes have to be approved within 30 days or at the next meeting, whichever is later, and then posted on the website. Another important premise of the Open Meetings Act is that the minutes of closed meetings that are required to be kept verbatim have to be reviewed semi-annually to determine whether the need for confidentiality still exists or whether those minutes can be released as public minutes after an appropriate vote. Additionally, members of the public have the right to address public officials under the rules established by the body at an open meeting. Remedies for non-compliance: any person may bring a civil action. Next slide, please. Next slide, please. Any person may bring a civil action for non-compliance of the Open Meetings Act in the circuit court, or they can request access by the public access counselor, similar to the Foia process. If there's a violation, if it's determined that there has been a violation by a court of any of the terms of the Open Meetings Act, that can be a Class C misdemeanor, however, not for the training requirements. That part, that they give you some leeway on that. Next slide, please. Next slide, please. And as similarly with Foia, there have been some changes made as a result of the pandemic. The Open Meetings Act was actually amended to give broader parameters for remote meetings when there is an emergency declared or a disaster declared, as we have now during the pandemic. It has always been the case that members could attend via remote means if the public body had rules for that. But now there are more individuals who can be present remotely, so long as there is one member of the body or council present at the physical location of the meeting. The other notable change is that roll call votes are required for all of the meetings that are held with remote means, so that all individuals can be identified by their presence and their vote. So that is what I have to tell you about Foia and the Open Meetings Act. And if anyone has any questions, I'm happy to talk to you here or contact me directly later. If you need help with the training requirement, I'm also happy to assist with that.
Thank you for your expediency in doing that presentation. Are there any questions?
Ken Shepro, question?
Yes, Mr. Shepro.
Aaron, my understanding from talking to the Attorney General over the years is that a regularly scheduled meeting may be held on a public holiday, but a special meeting may not be.
That's a nuance I'm not familiar with. I will look into that and get back to you, Mr. Shepro.
Thank you.
Madam Chairman, this is Alan. I have a question.
Yes, Mrs. Allen.
Thank you. Ms. Brady, can you give me an example of a commercial FOIA request?
Sure. For example, let's see. A mortgage company could submit a FOIA request to either, the treasurer's office or county clerk's office, seeking information about tax bills that are not yet due or not paid, in an effort to either market to or some other means to seek out revenue for or take advantage of that process.
Thank you. That's great. I just couldn't quite summon that up myself. Thank you.
Yeah, we see those occasionally.
Yes, Mr. Caius.
Brady, Chris Caius. The 48 hours, is that business hours or is that?
Regular hours.
Just regular hours, so over weekends?
That's right.
Holidays, anything. Thank you.
It has to be posted though, correct? As clarification?
The posting, yes. So the notice requirement is 48 hours. And that means that, our process is that we send out an email with the agenda on it. But what what the language within FOIA is that it's got to be posted at the location of the public body and put on the public body's website if the public body has one. And so that's how we do that, and we do the email blast.
Yes. That's my understanding as well. Any other questions?
Sanchez here.
Yes, Mr. Sanchez, welcome.
Thank you. Thank you, Madam Chair. Ms. Brady, I'm sorry if you had mentioned this in your presentation and I just missed it. But typically we think of an open meeting in the context of county board members, but isn't it also elected officials? If there are a number of elected officials outside of the county board that are discussing county business together, does that qualify also as an open meeting that would require notice?
No, it goes to looking at the public body. So if they're not on a committee together that could make a final decision about something, that's not really what the Open Meetings Act contemplates. It contemplates the actual decision makers getting together to discuss public business outside of a open meeting.
Shepro, could I comment on that?
Yes, Mr. Shepro, of course.
Yeah, Jared, I believe that it is how those officials are characterized. So for example, when the previous chairman appointed a task force that consisted of elected officials, the auditor, the treasurer, supervisor of assessments, and so forth, I believe that that was then determined that having been constituted as a task force, it was a public body and subject to the Open Meetings Act. However, if the chairman had just chose to talk to those people, that would, and it was not formally constituted as a task force, I believe that then that would not be subject to the Open Meetings Act. I defer to Councilor Brady on that.
Yeah, there are circumstances under which a situation like that would be, considered a public body, but without knowing, specifically the roles and examples and there's a long analysis for whether or not something is a public body. But yes, that I can envision circumstances where that would be the case.
Any other questions?
Alan, can I follow up on that?
Of course.
Thank you. If the task force is just coming together to make a recommendation, as opposed to making a final decision, does that make a difference in whether it needs to be posted?
It can't, I don't think it could hurt to treat it as an Open Meetings Act required situation. I'm hesitant to give a response without having, on a hypothetical, but as I mentioned, there are a number of factors that would go into a judge determining whether or not something was a public body. But I think the way I would answer your question would be to have everybody and encourage everybody to err on the side of treating it as a public body and noticing it. If there's something specific that someone has in mind that they want to address with us before they have a meeting like that, we're always willing to chat about that. But, like I said, it couldn't hurt to do it that way.
Sure, Ken Shepro, the act says that a majority of a quorum of a public body where public business is discussed. And so I think in the past, as Aaron points out, even advisory bodies, for example, I recall a famous case involving a current member of the state's attorney's office where the school district in Geneva constituted a parental advisory committee. It did not have any decision-making powers, but recommending powers. And it was pointed out that nonetheless, they were a public body, having been constituted by the school board and had to follow the notice requirements.
Thank you, Mr. Shepro. And what we need to remember is what Ms. Brady said at the very beginning. All of this tends to be interpreted broadly rather than narrowly for the benefit of the public, which makes perfect sense. So thank you.
Okay, thank you both. Yes.
Trustee Berman, I don't know how thorough you mentioned the consequences if you violate the
Open Meetings Act?
There can be, now I'm blanking, now that you asked me that directly through the flow of the process, I could have just told you. There can be misdemeanor requirements except for that training requirement that I mentioned. But there's a sentence in there that just broadly says violations of this act can be punishable by a Class C misdemeanor.
Could I add again that a court may in its discretion void any action that was taken in violation of the Open Meetings Act? They don't have to, but they can.
Yep, that's a good point.
Yes.
So I think it's to be safe if there's 3 people gathered together who are all elected officials, it becomes a meeting and it's part of the Open Meetings Act. And it's best to allow us to help you put that agenda together and to post that so that we can have a formal meeting where the public acknowledges the fact that you're going to be together to make a decision or to discuss a matter.
Okay, thank you for your time.
Any other comments?
I think the best comment from that we heard is when there's really, if it's a gray area, you should always resolve it in favor of openness unless you have a definitive opinion from the state's attorney otherwise. I think that's a good rule of thumb.
Absolutely. Thank you for that. So thank you, Ms. Brady. Appreciate that. That ends our agenda unless there is an executive session required.
If you
Yes.
want, I'd move we adjourned.
Since the light is waning in here and I can barely see my notes, I would concur. May I, we already have a motion. Do I have a second? Mr. Berman? Clerk, please call the roll.
Aye.
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 Passes.
Aye.
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 Bye.
Thank you, everybody.
Goodbye.
Goodbye.